SJC-11471, Commonwealth v. Albert Newson.
Good morning, Mr. Bateman.
Good morning, Justice Gantz and members
Wait
of
a
the court.
moment until we can start your clock, and then you can proceed, and now you may.
Okay, thank you. This case involves the legal issue whether a defendant is entitled to a jury instruction based on his theory of defense. I'm going to address that issue first, then I'll address the second issue involving the Miranda waiver and its validity. This case can be summed up in a couple the facts of the case can be summed up in a couple sentences. It involved a drive-by shooting at a housing project. Two guys, at least one person got out of the car, shot someone, and got back in the car and drove off, followed by high-speed police chase. And at that location, two people did get out of the car. One of them, the defendant in this case, was apprehended nearby.
There's no question, is there, about identification of your client as having driven the car?
He said he drove the car. He testified on his own behalf and said he drove the car. And that's what's unique about this case. We have a defendant who got up there and went on for pages and pages of transcript, probably minutes and minutes at trial, and forthrightly said, I was in the car, but I wasn't the shooter. I was the driver. And he wanted an accessory after the fact instruction. And he proposed it. It was denied by Judge McAvoy, and the issue was fully preserved. The obvious reason why the defendant wanted a accessory after the fact instruction is because a defendant who's convicted of accessory after the fact cannot be convicted of murder based on settled law in Massachusetts. Accessory after, just to clear up one item, accessory after the fact is not a lesser included offense of murder in any jurisdiction I know of. It was in California for a while, but they've since reversed. So he wanted an instruction that would make very clear to the jury, if you believe the defendant's testimony of his role in the criminal transaction, he can't be guilty of murder. That's why he wanted it. The judge denied it.
Well, there was no accessory after the fact charge. We had a case a month or two ago in which the Commonwealth charged both. This is not that case.
No, there was the Commonwealth, for whatever reason, made its decision not to indict him on that charge. That's correct.
So, and the judge did make clear that if you find that all he did was help in the escape and did not share the intent to kill, that you should find him not guilty.
She gave one sentence. It is not enough to show simply that the defendant aided after the fact with escaping the scene or disposing of the weapons. It's on the transcript page of volume 7.
Which is what he said is all that he did.
Yes, that's what she said.
No, I mean, but that's in terms of the argument. Your
Right.
argument is that's all that he did.
His argument, he drove the getaway car. He gets back in the car. He testifies. They told me drive, and so he takes off in a high-speed chase across a major thoroughfare in Dorchester, and eventually they catch him.
Why should a judge? It's not clear to me, and you of course have some case law that is contrary. But why should we change the case law that is contrary to say a judge must instruct a jury about a crime that is not charged?
Well, it acts as a defense in this case. When you think about it, how different is this from self-defense, lack of criminal responsibility, other affirmative defenses? This crime was used as a defense. In other words, he did this, but if he did this, he's not guilty of the other offense. And
But she gave that. I mean, she did recognize you had a very able judge who understood your argument, and she made it clear to the jury that if all that he did was help them escape after the crime and that he did not intend the killing at the time of the killing, you should find him not guilty. That seems to be all that you'd be entitled to.
Well, it's how the jury instructions frame the way the jury is supposed to look at the evidence. And in every murder case that I've ever seen, one of the questions comes up is, well, what is the prosecution's theory? Is it extreme atrocity and cruelty? Is it premeditation? Is it felony murder? And so that frames the jury instructions. And if a defendant, if there's evidence in the record suggesting self-defense, the defendant gets a self-defense instruction. If there's evidence of lack of criminal responsibility, you get a McCool instruction. And in this particular case, the evidence clearly in the record is that he only was the getaway car driver, and he did not have any, his testimony was, I didn't know they were going to jump out of the car. I didn't know they were armed. I didn't know there was going to be a shooting. I was the getaway car driver. So in terms of a framing the jury's evaluative process, it would have been very helpful. Certainly would have been helpful to the defendant, and it would have clarified. It would have clarified the entire case. There's the Dean case, which talks about will it confuse the jury. I don't think this would. The record would certainly suggest it would, based on his testimony, would not have confused the jury. Would it have been burden shifting? I don't see why it would have been certainly any incremental. I don't think it would have any burden shifting at all. The Commonwealth always has the burden to prove everything.
Did the counsel not able to argue this?
Well,
I mean, wasn't counsel able to argue that he didn't do anything other than help them escape? He didn't know anything.
He was limited.
How was he limited?
He was limited. He could not get up there and say, and it was prior Attorney Nyman. He did a great job on this. He was limited. All he could say was, well, I'm here to, and it's in either the Commonwealth's brief or it's in my brief. The exact paragraph. It was right at the beginning of his argument. It was very limited to the effect of, I can't get up there and say that the defendant is not guilty because he was only, if he was guilty of anything, he was guilty of being the accessory act of the fact. And you cannot convict him of murder because he was guilty of accessory fact.
Why can't you say you can't convict him because what he did isn't enough? I mean, what Judge McAvoy instructed was what he said he did. And if that's the case, why can't you just argue he can't be guilty of murder? He can't be a joint venturer because he didn't share their intent. He didn't know that they were going to kill him.
He can,
and he didn't even know they had guns.
He certainly could argue that.
And all he did was
facts in the record.
Did he argue that?
Yes. He certainly argued that based on all the evidence.
The judge didn't stop him from arguing that.
No, she didn't stop him from arguing that. But he still couldn't get up there and say very clearly to the jury, if you find he was just the driver of the getaway car, and that's all he had no shared intent, and he
then he can't be guilty of murder.
And he can't be guilty of murder.
Why can't he argue that?
Well, he couldn't say that because he didn't have the jury instruction in the record. The jury was never instructed on that. So he'd be matter of fact, it might have a different claim if he had done that. He might have been an ineffective assistance of counsel claim. You can't argue that he was guilty of a crime when there was no jury instruction for the crime. So, bottom line was, let me add one other point. The evidence in this case was not overwhelming.
Before you get there, did Judge McAvoy provide the jury with written jury instructions?
I don't remember.
Did she provide counsel with her written jury instructions during the charge conference?
No, I don't remember that. I don't remember that, but the counsel clearly knew that he was not getting the accessory after the fact.
I guess my question then, more precisely, is: did counsel know he was going to get in the instruction which he did get, which is a precise instruction?
Yeah, she said he would argue. She said she did in the charge conference. She did say that she would say something about it.
So the counsel could have argued, you will hear from the judge that if all that you find is that he was involved in the escape and did not participate in the murder, you must find him not guilty. He could have argued that based on her instruction. I would suggest he was certainly on notice of the limited instruction that she did give.
But that's still very different from having a full-blown instruction on accessory after the fact and being able to get up and argue to the jury that if he was guilty of accessory to the fact, then he does not have liability for the underlying murder. It changes the entire tenor of the jury instructions. Let me just very briefly, in terms of overwhelming evidence, this case was not, in my view of the record, overwhelming evidence. They said that the shooter was wearing, various witnesses said the shooter was wearing a gray hoodie, and a hoodie had been found in the neighborhood, and that he had GSR evidence on him. No one got up there and said, this is the man. There was no identification testimony. So from that standpoint, this would have been very helpful. And unless there are any further questions on that issue, I'll move on to the Miranda issue. This is based on a recorded interrogation. Almost the first word out of the defendant's mouth when they turn on the tape recorder is, "Am I under arrest?" And Detective Harris goes, "Situation fluid, you're not under arrest."
Am I under arrest for the murder?
Oh, he wasn't charged with the murder until much later.
No, I know that, but I mean, wasn't he really asking whether he was being charged with the murder?
I don't think he knew what he was asking for. I think he wanted to know. I don't think he...
A place called homicide?
Oh, yes. From that, yes, of course. Yes, absolutely. He thought he was in the homicide unit. Why else would he be there? That's correct.
Now, the judge found that the interrogating officer did not know that he was under arrest until the third break.
That was the finding. On the other hand, arrest for the drug charge until after the...
He was not arrested for the homicide till
right, till much later. That's right. But for the drug charge. On the other hand, okay, this defendant was caught at the scene, put in handcuffs, brought to the homicide unit, and he was under arrest for something. And even Detective Harris said
he was under arrest for something.
Under arrest for something.
The officer didn't know that until...
Well, the officer, Detective Harris, either in the motion hearing or at trial, I'm not sure where he said it, but he said it was based on the collective knowledge. Okay, and it was a fluid situation, and it was really. I think it's even in Justice McAvoy's ruling, the collective knowledge. So if we have the collective knowledge doctrine that says that we can rely on all the officers' collective knowledge to have probable cause to arrest, then one could certainly argue that the collective knowledge doctrine applies to knowing whether he's under arrest. And
could you explain a little bit about the circumstances that unfolded? He had been placed under arrest, brought to the police station. He hadn't been brought to booking.
No.
And how did he get from the police station, the outside of the police station, to whatever room he was interrogated inside?
He was in he was picked up on the street, put in a police car, put on handcuffs, brought directly to, as I understand it, the record says, brought directly to the homicide unit, sat down outside, proceeded to throw up in the lobby.
In handcuffs? His handcuffs weren't removed?
I don't think the record, the record says that he was not in handcuffs during the actual interview. Okay, but it's unclear to me that is unclear to me.
But does the record indicate when the handcuffs were removed?
I don't think so.
Who removed them?
I don't think so. Okay. I know they were removed. It says they were removed. But he was the other factor involved in this is that he clearly was drunk, or he was whether he was intoxicated. You know, the level, his blood alcohol level is at that point is unclear. But he threw up. Detective Harris said, you know, you could smell the alcohol. He reeked of alcohol. But Justice McAvoy did make a finding saying that he was not impaired, at least for the purposes of his Miranda, both the Miranda waiver and general voluntariness. what I'm arguing.
But she said that was informed because she listened to the audio tape and has that footnote which says this is one in which DG and Batista may have saved the government.
Yes,
because
that's true. And I've listened to it, you can listen to it as well. On the other hand, the evidence is overwhelming that he had been drinking a lot. And he smelled of alcohol, reeked of alcohol, threw up in the lobby, what have you. And that's just when in this court's Miranda analysis, it's based on totality of circumstance. It's based on totality of not only totality of circumstances, but any one example of trickery probably does not prevail for the defendant. On the other hand, if there are other factors at work, like is the guy under the influence of alcohol, and how under the influence of alcohol is, then it gets a little more complicated.
Now, Judge McAvoy didn't have much to say on the trickery point because she didn't understand, apparently, the argument that was being raised, or it wasn't much of an argument that was raised.
That's what she wrote. On the other hand, this issue was clearly presented to Judge McAvoy in the motion hearing at page 72. Okay, there's a reference to it in my footnote of my brief. But clearly, as a matter of fact, what she said. I'm reading on page 72 of the motion to suppress transcript. Mr. Neiman, you're absolutely right, and that's because from the very outset of this case, my client asked the question, so am I being arrested? And Detective Harris says, no, just because I read your rights, this is just an interview at this point. So that's right there is the trickery. So she was on notice of the trickery claim. She did not address the trickery claim, at least that part of the trickery claim.
Is that the only reference to trickery in the motion to suppress transcript? Because, it's not like she didn't get the point that was a point being raised. It was that she was saying, well, what's the argument?
I thought it was very clear that the issue was raised, and the argument was that he was tricked into his Miranda waiver because he thought he was not under arrest. And
But didn't the detective not know he was under arrest until sometime later?
Much later, almost.
Are those inconsistent findings?
I don't know about inconsistent, but there's clearly maybe I don't understand the question.
My guess, the inconsistency that's sort of coming at me is, how can the judge find that the detective did not know that your client was under arrest?
She didn't say that. She said, I did not know, that detective did not know he was under arrest for the drug charge until later on.
Oh.
She didn't say that's you're right on that. But it wasn't until much later on, and that's when, and the way this came up was he said.
Well, wait a minute, but that's still, is that what he was arrested for, the drug charge?
Mm-hmm.
So it's coming right back at me. The detective is telling him, or suggesting to him, that he's not under arrest, but which means that the detective knows that he's under arrest, but the judge makes a finding later on that says the detective didn't know that he was under arrest for the drug charge until sometime later. Isn't that inconsistent?
Seems to be, but I didn't read it that way. I read it that Judge McAvoy found that he didn't know he was under arrest, at least for the drug charge, but
she did. She concluded that there had been some trickery.
No, I don't think she concluded that.
Okay.
I didn't read it that way. I read it that she never really addressed the trickery dealing with the arrest. There were other arguments that you'll see in the transcript about trickery, statements that were made, which probably do not rise to the level of trickery under the law of this Commonwealth. But
well, I take it that Detective Harris didn't make the arrest on the street, right?
No, it was somebody else.
Yeah, he was arrested. Turns out he had marijuana in his possession, right?
True.
Right. So he was brought to the homicide section to be interviewed by the detectives.
Right.
Okay, so they didn't know that in fact marijuana had been found on his person, and that he was going to be arrested for that.
Well,
I take it he wasn't booked before he was interviewed
No.
by the homicide detective.
No. He, I mean, I don't know what Detective Harris knew. One can infer from the record that he knew that he was picked up after this chase and picked up on the street, pursued. There was he was chased in the neighborhood. At least they tried to find him in the neighborhood, and he was brought to the...
There's no question he's in custody, so, I mean, that's not an issue.
No, the issue is, did Detective Harris, either by negligent misrepresentation or affirmative misrepresentation, misrepresent the fact that he was under arrest? And the defendant relied on that, and as soon as I see my time is out, may have 10 seconds here, and based on that reliance, he gave the statement. And unless you have any further questions, I rest on my brief.
Great, thank you.
Good morning, Your Honors. May it please the Court, Elizabeth Martino on behalf of the Commonwealth, and with me is Assistant District Attorney Julie Higgins and David Fredette, who are the trial prosecutors in this case. And I note also that the family of Thomas Webb, who was the victim in this case, they are in the courtroom. I don't have that much to add over and above what's in my brief. Just quickly on the first issue, the trial judge did, I think, follow what this court had said in Commonwealth versus Dean, or suggested in Commonwealth versus Dean is the best practice in a case such as this, where the defendant is asking for an accessory after the fact instruction, but he wasn't charged with accessory after the fact. This court suggested, you don't give a separate accessory after the fact instruction because it can be confusing to the jury, but what you can do, where appropriate, is explain to the jury the defendant's theory of the case, that he merely assisted in covering up the crime or escaping, aiding in the escape, but didn't actually participate. So Judge McAvoy did that. She explained to defense counsel that's what she was going to do. She added in the model joint venture instruction a line saying that it is not enough to simply aid in the escape or to discard weapons to be liable for murder. Counsel was aware that that instruction was going to be given, and he did argue to the jury that what the defendant did in this case did not rise to the level of murder, and so he should be acquitted. So that's really all I have to say as to the first issue, unless there are any other questions on that. And just...
Did Detective, does the record indicate how Detective Harris learned that the defendant was in the police station?
Yes, so he testified at the motion to suppress hearing. I think that he originally went to the scene, and then he was notified by police officers that there was somebody back at the homicide headquarters that was to be interviewed, so he went back there.
And that was the extent of it?
Yes, so...
And does the record indicate who removed the defendant's handcuffs?
No. And I apologize, I think I misspoke. It wasn't the extent of it because Detective Harris was also questioned at the motion to suppress hearing when he learned that the defendant was going to be arrested for the marijuana possession, and that, he said, there were two breaks. So there was an interview, first portion of the interview, then a break, then a second, then a break, and then a third. And it was during that second break before the third portion of the interview that Detective Harris said he learned that the defendant was going to be placed under arrest for the marijuana possession. And it was during the third portion that he told the defendant, no, you can't leave because you're going to be placed under arrest. What was on you when you were stopped? Marijuana, yeah, you're going to be arrested for that.
Now, how was it that he was put in cuffs to begin with? I mean, that he was taken from the street for questioning, but I mean, was he arrested?
The record doesn't bear that out. I don't know.
But he was in cuffs when he was, I mean, he wasn't happily going to this interview on his own.
No, it was certainly custodial interrogation. There's no question.
Well, but he arrived at the police station in handcuffs.
Detective Harris said he assumed that there were handcuffs. I don't think it's clear from the record. I mean, he said, I assume he was in handcuffs. I'm not sure. He was questioned on that issue. But I'm not sure that matters in the long run because, there's no question that this was custodial interrogation, that the defendant didn't want to be there, that he was taken from the scene to homicide, and that he was detained to be questioned.
Well, if he had been arrested for possession of marijuana and handcuffed and brought to the police station, and if Detective Harris knew that he either was in handcuffs or had been arrested before the interrogation started, it might make a difference. Not to the fact that it was custodial interrogation, but to the answer to his question about whether he was under arrest.
Well, I'm not sure that it does, because under the cases,
So even if, it's your view that even if Detective Harris had lied and said, no, you're not under arrest, that's okay?
Yes, because a police officer isn't required to tell a person that they're a suspect or that they're going to be arrested, or even necessarily the nature of the crime that they're being questioned about. What's important under the case law out of this court and the appeals court is that the defendant understands the nature of the Miranda warnings and that he knowingly and intelligently waives those. And then further, you know, and the voluntariness, that he's not coerced, that his statements are given as a product of his free will. There's no, I think, evidence here that his will was overborne just by virtue of being told, no, you're not under arrest. I think the cases are clear that there's no requirement that an officer tell a person, even if the officer knows that they're under arrest, that is the case. So I think first, you know, our argument is that factually the defendant's claim fails because Detective Harris didn't know that the defendant wasn't under arrest until the third portion, but even if he did, which is not the finding of Judge McAvoy below, even if it was a lie, it's not the type of lie that rises to the level of a false statement requiring suppression. And if the court has no other questions, Commonwealth rests on its brief. Thank you.
Thank you.
No, no. I could be.
Anything else?
It's all yours.
Right.
Oh, am I?